Hello everyone, very good evening. Welcome to AS for CS classes. Myself CS Arun Marepally from Hyderabad. So before I start up, let me thank ICSI because lots of queries and problems that was faced by the students with respect to the new topics that is being added up. Certainly they did, they understood the problems too. So we have got a clarification that whatever the new topics that is being added up by the recent inclusions, that will be applicable from the June 2021 attempt. So whatever the normal amendments that have come from Jan to June 2020, so only those amendments will be applicable for the December attempt. So no new more topics that is been added for the December attempt. Clear everyone? Not only this subject, whatever the new modules that is, whatever the new topics that is been added up for all the subjects, whatever the subject it may be, that will be only applicable from the June to 2021 attempt. Clear? So now the agenda for this particular session will be understanding the amendments what we have got with respect to the governance subject, that is both of Companies Act and the SEBI regulations from January to 2020 to June 2020, which will be applicable for the December attempt. Clear everyone? First of all, we will be discussing about the Companies Act amendments, then we will go to the SEBI regulations and the some new topics that is being added up for the December attempt. So that topics will be discussing. Clear everyone? Now the first one, under the Companies Act. So let us understand, let us follow the same procedure. We'll understand the concept, then we'll move to the PDF part. Clear? Now, two amendments have come with respect to the independent directors. One, as we already discussed, so the independent directors and the non-executive directors will be liable only if at all whatever the default made by the company, if such default is made with the knowledge of that independent directors or the non-executive directors. That means if at all any company makes any default of any of the provisions, or they make any non-compliance of any particular provision of the act, whatever the act it may be, generally the officers in default will also be made liable, and for that officers in default, the independent directors and the non-executive directors shall not be. For the non-executive directors, it shall not be relating to the promoter. So who is an independent of the promoter group, that is a non-executive director and an independent director, they will not be made liable for the non-compliance or the defaults made by the company, and they will not be held for any prosecutions unless whatever the default or the non-compliance that is being made, if at all such things are made with the knowledge of such persons, be it an independent or the non-executive, then they shall be made liable. Clear everyone? Now see what it says. The General Circular number 1/2020, clarification on prosecutions filed or internal adjudication proceedings initiated against the independent directors or non-promoters and non-KMP non-executive directors. Non-promoters is what they are using. So they are not relating to the promoter group nor the KMP, and they are the non-executive directors. It is dated 2nd March 2020. This circular clearly shows that Ministry resolve and intend to give a protection to whom? To the independent directors and the other non-executive directors. Other non-executive directors from what? From the prosecution for both civil and criminal offences, unless, very important line, unless there is a strong evidence against them that they being a party to any fraud committed by the company. That means unless you have such an evidence, a strong evidence, so that you could prove that these non-executive directors or the independent directors are involved in that particular non-compliance or the fraud made by the company, only then these two category of directors will be made liable, or any prosecutions may be initiated against such particular independent directors or the non-executive directors who are not relating to the promoters or a KMP. I repeat, say for example, if I being a promoter of a company, where I being an MD, say for example, my brother Mr. B is a non-executive director. My brother Mr. B is a non-executive director on the board of that listed company or whatever the company. Now, the company have made a default or the company have made some fraud. The question is whether Mr. B will be held liable for that or not. What our provisions say, sir, the exemption is being provided only to the independent directors and to the non-executive directors. To the non-executive directors, but the provision for that is that non-executive directors shall not be related to the promoters or a KMP. Now Mr. B being a non-executive director, but he is related to the promoter group. He is related to the promoter group. Then you cannot take the shelter of this particular clarification. That means two important things. First of all, you shall be a non-executive director and you shall not be related to the promoter or a KMP of that company. Then if such is the case, then such independent director and such non-executive director who is not a promoter, it is not related to the promoter or promoter group or to the KMP, then those people will not be held liable unless you have a strong evidence that they are involved in such fraud. Clear everyone? I repeat once again. It gives a protection to the independent directors and other non-executive directors from prosecution for both civil and criminal offences unless there is a strong evidence against them that being a party to any fraud committed by the company. Sir, you have a particular evidence that sir they are involved in this particular fraud. Only then these independent directors and the non-executive directors shall be made liable and can be prosecuted. Section 149 subsection 12 of the Companies Act 2013 is abstent clause which provides an independent director and a non-executive director not being a promoter or a KMP shall be held liable only in respect of such acts of omission or a commission by a company which had occurred with his knowledge, very important, with his knowledge attributable through a board process and with his consent or connivance or where he had not acted diligently. So three important things he is saying there. What is that? Sir, these independent directors and such non-executive directors who are not a promoter or a KMP, nor related to the promoter or a KMP, they will be held liable when, if at all, whatever the acts of omission or a commission made by the company, such omissions or commission, that is a frauds or some non-compliance made on part of a company is made with the knowledge of that particular director, with the knowledge of that directors. Here directors means your independent directors and the non-executive directors. So with the knowledge of that particular directors or attributable through the board process, you are involved in that particular board, you knew that this company is making some fraud, still you haven't made or you haven't given any alarm that sir this is going beyond the law, and with his consent you are aware of that particular non-compliance, you are aware of that particular fraud, or even you have given a consent for that particular fraud and you have an evidence for that, then you could be prosecuted. Or the last one, connivance, or where he had not acted diligently, then only in such case these independent directors and the non-executive directors who are not related to the promoter or a KMP, they will be held liable. So in a nutshell, generally whatever the fraud that made by the company, the independent directors and the non-executive directors shall not be held liable. Non-executive directors, you have to mean that they are not relating to the promoter or a KMP. So in general rule is that these directors will not be held liable and they cannot be made subject to the prosecution. But if at all such fraud is being made with the knowledge of such directors, with the consent of the directors, with the connivance of that particular directors, then you may be prosecuted, you may be held liable for that. Clear everyone? And you possess a strong evidence, that is alleging party or the authorities possess a strong evidence to prove that you are involved in this particular fraud, then the independent directors nor the and the non-executive directors cannot take a shelter that sir we are not liable for that particular acts or activities done by the company. Clear everyone? And in view of this expressed provision of section 149 subsection 12 of the Companies Act, independent directors and the non-executive directors not being a promoter or a KMP should not be arraigned in any criminal or civil proceedings under the Act unless the above mentioned criteria is met. That means, sir, the independent directors and the non-executive directors shall not be made liable, be it a civil proceedings or a criminal proceedings, unless the clauses what we have seen here, that is about your with your knowledge or with your consent or with a connivance, or you didn't act diligently. If such criteria is met, then you may be drawn for the prosecutions. Otherwise, you will not be held liable for any of the liabilities. Clear, everyone? Then MC has clarified that at the time of serving notice to the company during inquiry, inspection, investigation or adjudication proceedings, etc., necessary documents may be sought so as to ascertain the involvement of concerned officers of the companies, and due care must be taken to ensure that unnecessarily any civil or criminal proceedings is not initiated against the independent directors or non-executive directors unless sufficient evidence exists against them. Sir, whenever these authorities comes to know that the company have made certain fraud and these authorities are issuing any notice for any inquiry or a further investigation to the directors of the company, the authorities shall take care that these notices are not being sent to these independent directors, or unnecessarily you shall not take any actions against such independent directors and the non-executive directors unless you possess a strong evidence that yes, these directors are involved in this particular offense. Clear, everyone? So what it says, ensure that unnecessarily any civil or criminal proceedings is not initiated against the independent directors or non-executive directors unless when you have a sufficient evidence against them. So if at all you have a sufficient evidence so that you could prove that they're involved in this particular fraud, then you issue notice to these independent directors and the non-executive directors and they may be prosecuted. Clear, everyone? So the records available in the office of registrar, including the e-forms DR11 and DR12, along with the copies of annual returns or the financial statements, should also be examined so as to ascertain whether a particular director or a KMP was serving in the company as on date of default. So as on date of default, you need to ascertain as to who are the officers in default. So certain documents which are available with the registrar, the authorities may look into so as to ascertain who are the officers in default for that offense committed by the company. In case any doubt with regard to the liability of any person for any proceedings required to be initiated by the registrar, guidance may be sought from the Ministry of Corporate Affairs through the Office of Director General of Corporate Affairs. So in order to proceed further with respect to this type of investigations, where if the registrar requires any sort of information, then the MCA ministry provides a guidance with regard to such investigations. Clear, everyone? This is what the amendment with respect to the prosecutions on part of the independent directors and the non-executive directors. So in nutshell, the exemption is being provided to the independent directors and to the non-executive directors, but they shall not be relating to the promoter or a KMP. Then against these two individuals, against these two directors, no prosecutions can be initiated unless you could prove that they are involved in that particular fraud. Clear, everyone? You have a sufficient evidence to prove they are involved in that particular fraud. Clear, everyone? This is the first amendment, and you could see this these concepts in your chapter 2 and chapter 3. Chapter 2 and chapter 3. Clear, everyone? Clear? Can we move ahead? Then one more concept with respect to independent directors. Now, there is a particular website which has been developed so as to maintain the independent directors data bank, whereby if a person has already been appointed as an independent director in any existing company, or if any person who intends to be appointed or who intends to act as an independent director in any company on a future date, shall compulsorily register himself with this independent directors data bank. A particular website has been provided where you provide all your basic details in that particular data bank. You register there you pay the prescribed fees, that is of 5,000 odd for 1 year, and you have a lifetime fees too, that is of 25,000. So you register yourself in that particular website and pay that particular fee, and also you need to write a particular examination and you have to pass that particular examination. Only then you'll be having a right, you qualify, and you'll be eligible to act as an independent director of the companies. I repeat, whoever already been appointed as an independent director of a company, or who intends to be appointed as an independent director of any company, shall compulsory register himself with the independent directors data bank by paying a prescribed fee, and also not only the registration plus the examination. So passing of examination, you have a particular syllabus for these independent directors. So you need to pass out that independent directors examination. Only then you'll be qualified to act as an independent directors of the company. Clear, everyone? Now look into that. MCA by notification number 145, by virtue of the company's appointment and qualification of directors amendment rules 2020, dated 20th February 2020. So what it says, compliance is required by a person eligible, very important, eligible and willing to be appointed as what? As an independent director. What is that? Every individual, first part, who has been appointed as an independent director in a company. So first part, you already been independent director, you're acting as an independent director in the existing board of a company. I repeat, sir, I'm already an independent director of the company. I'm already an independent director of the company. Then on the date of commencement of the company's appointment and qualification of directors, 5th amendment rules 2019. So as on today, as on that particular date, if I'm an independent director of a company, then he shall, I myself, within a period of 10 months from the commencement of this particular rules, within 10 months from the commencement of this particular rules, or 2, who intends to get appointed, the first one was, he was already an independent director in a company as on date of this particular rule. The second one is not yet appointed, but after the date of these rules, he may be appointed on a future date. He intends to get appointed as an independent director. Then, who intends to get appointed as an independent director in a company after such commencement, shall before such appointment, that means, sir, the first part was within 10 months from the commencement of this particular rules. If at all you already been an independent director in an existing company, you register yourself with the website. Second one, as on date of commencement of these rules, you are not acting as an independent director. I repeat once again, clear everyone. Sir, as on date of commencement of these rules, you are not an independent director, but after the commencement of rules, you intend to be appointed as an independent director of a company. But what is the qualification for that? Apart from the eligibility criteria that you have as per 149, first of all, you have to register yourself before your appointment. It is not after the appointment. The law is very much clear. It says shall before such appointment. So before you are being appointed into the company, on the board of the company, you apply online to the institute for the inclusion of his name in the data bank. So you apply to that particular through that particular website for inclusion of your name in that particular independent directors data bank for a period of 1 year or 5 years or for lifetime. So you have three things here. One, for 1 year or for 5 years or for lifetime. So you have specific fees for each and every slab rate over there. For 1 year it is 5,000, for 5 years it is somewhere around 15, and for lifetime it is somewhere around 25,000 odd plus GST. So you apply for inclusion of your name to that particular data bank for a period of 1 or 5 years or for lifetime, and from time to time take such steps as specified in Rule 6.2 of the company's appointment and qualification of directors rules 2015, till he continues to hold the office of an independent director in any company. That means, sir, it is not one time. So today, if at all I'm intending to be appointed as an independent director, I registered myself in that particular data bank for 1 year. But after 1 year also I'm continuing as an independent director, then it is not the criteria. So, sir, till you continue to be an independent director of a company, till you continue to be an independent director of a company, this qualification shall be met. This compliance shall be met. That means your name has to be there in your independent directors data bank. So once this 1 year has been done, you have to apply for the renewal or by payment of that prescribed fee. Clear, everyone? So two things over there. One, I'm already acting as an independent director. Two, I'm not an independent director as on date of the commencement. The first case, if at all I'm already an independent director, then within 10 months I shall apply online to that particular website, that is Independent Directors Data Bank, where I have to include my name in that particular data bank within 10 months. The second one, if I'm not an independent director as on date of that commencement, but I intend to be I intend to be appointed as an independent director of a company, then before you get appointed, you register yourself, you apply through online to that data bank for inclusion of your name. Only then your appointment will be valid. Clear, everyone? For whatever the period, that is 1 year or 5 years or for a lifetime, by paying the prescribed fee, you include your name in that data bank, then only you can be appointed as an independent director. Clear, everyone? This is a prerequisite for the appointment of independent director, my dear friends. Very important one. Expected question for the December attempt. This is a prerequisite for a particular director to be appointed as an independent director of a company. Then, an individual shall not be required to pass the online proficiency self-assessment test. Yes. Now, apart from this registration in this particular data bank, that is first one. Second one, you need to pass, besides with respect to registration in the data bank, you need to pass an online proficiency test so that you could be appointed as an independent director. Sir, why come this independent directors examination, sir? Sir, independent directors of a listed company, they are, there is some expected role and responsibility on part of these independent directors. They need to check on the company as to progress of the company, and also with respect to the financials and non-financial terms, where it is expected from the on part of independent directors that they possess certain quality and the qualifications. They possess some particular knowledge on that particular field. They should have a knowledge on the corporate laws. So in order to maintain that, in order to escalate the board structure, the proficiency of that particular board of a listed companies, whereby the Ministry of Corporate Affairs have come up that, sir, whoever intends to get appointed as an independent directors of a company, be it a public or a listed company, first one, you should register yourself with this data bank. Two, you please write an examination, the self-assessment proficiency test, and pass in that. You have a criteria. So you pass that, only then you can be appointed, you're eligible to be appointed as an independent director of a company. Clear, everyone? It is not one way, two way. One, you register yourself. Two, write the examination, pass. Then you can be appointed as an independent director in a company. If at all you don't pass, then you will not be eligible. You will not be eligible. But certain exemptions have been provided with respect to the writing of examinations for the category of directors. Who are those? Look into this. An individual shall not be required to pass the online proficiency self-assessment test, when he has served as a director or a KMP, for a total period of not less than 10 years as on date of inclusion of his name, in the data bank. So say for example, today I am registering myself in this data bank. Then if at all I am serving as a director or a KMP for not less than 10 years, that is minimum of 10 years I have been serving as a director or a KMP as on today's date, in which companies? In a listed public company, in a listed public company or unlisted public company having a paid up share capital of 10 crores or more, or a body corporate listed on a recognized stock exchange. Recognized stock exchange. So a listed public company, unlisted public company having a paid up capital of 10 crores or more, or a body corporate listed on a recognized stock exchange. Then that means on the board of these three, if at all you are serving as a director or a KMP for a minimum of 10 years, then you have to register, but you do not write the examination. Sir, the exemption is provided only with respect to the online examination, but not with respect to registration. Very, very important. Sir, the exemption that is being provided over here is only with respect to passing of examination criteria, but not with respect to registration of the directorship, that is inclusion of name in the data bank. In the data bank. Clear, everyone? Provided, look into the provision there, provided further that for the purpose of calculation of the period of 10 years referred to in the first proviso, any period during which an individual was acting as a director or as a KMP, that is key manager personnel, in two or more companies or body corporates at the same time shall be counted only once. Very important. Look into that. Where an individual was acting as a director or as a KMP in two or more companies or a body corporate at the same time shall be counted only once. That means, sir, I am serving as a director in one listed company for 5 years, and I have been serving as a KMP in another company from the last 6 years. Then I cannot combine those two, 6 plus 5. Clear, everyone? So that will turn into only one. So what it says, which an individual was acting as a director or a KMP in two or more companies, then that is at the same time, then it shall be counted only once. Clear, everyone? The C is with respect to appointment of independent directors with respect to data bank. So in a nutshell, sir, as on date of this particular rule, you already been acting as an independent director of a company. Then within 10 months, register yourself with this data bank. 2. If at all you are not acting as an independent director as on date, but after the commencement of these rules, on any future date, if you intends to get appointed as an independent director of a company, then before such appointment, you apply yourself for the inclusion of your name in the data bank and also pass the examination. That is, passing of examination is both the case. Either you are existing independent director or intended to be getting appointed as an independent director. But an exemption has been provided to certain category of directors. Who are those? Where any individual who has been serving as a director or a KMP for not less than 10 years in a listed company, listed public company, or unlisted public company of a paid up capital of 10 crores or more, or a body corporate listed on a recognized stock exchange, then you need not pass in examination, but registration is mandatory. Clear, everyone? This is with respect to the inclusion of name and the registration of the name in the independent directors data bank. Clear, everyone? If at all time permits you, go to that particular website and have a look into that website as to how this registration process is being done. Clear, everyone? Can we move forward? Yes. Very important provision. The company's appointment and remuneration of managerial personnel rules to the amendment rules 2020 dated 3rd January 2020, where the appointment of company secretary with respect to the private limited companies, the limits have been increased from 5 crores to 10 crore. Rule 8A have been amended, where it says that every private company which is having a paid up share capital of 10 crores or more shall have a whole time company secretary. Earlier it was 5 crores, now it is being made to 10 crore. Clear, everyone? So what will be the impact for that? With this amendment in rule 8A, of the company's appointment and remuneration of managerial rules 2014, MC has clarified that every private company which is having a paid capital of 10 crores or more need to appoint a whole-time company secretary. Clear, everyone? Then the next amendment, MC has amended Rule 9 of the same rules, appointment and remuneration of KMP, managerial personal rules 2014, with respect to secretarial audit report. Secretarial audit report. So now every company having, expected question for examination, now every company having outstanding loans or borrowings from the banks or the public financial institutions of 100 crores or more is also required to annex the secretarial audit report with its board report. So it's stating every company, be it a private limited company or a public limited company, every company it is. So MC has also clarified that for the purpose of this rule, paid up share capital, turnover or outstanding loans or borrowings as the case may be existing and on the last date of latest audited financial statement shall be taken into account. So post amendment, the rule looks like this. The following companies are required to obtain a secretarial audit report. So every listed company, public company having a paid up capital of 50 crores or more, public company having a turnover of 250 crores or more, and this is amendment. Every company, so be it a private company or a public company, if at all they're having outstanding loans or borrowings from the banks or a public financial institutions, from banks or financial institutions of 100 crores or more, then such class of companies shall obtain a secretarial audit report from a practicing company secretary and annex that to the board report. Clear, everyone? And you'll be having that impact, these two provisions, inclusions in your chapter number 3 and chapter number 6. Clear, everyone? Yes. Moving ahead to the CSR amendments. So to the schedule 7, some new additions have been made with respect to spending of these CSR amounts. So due to this COVID-19 pandemic, so in order to curb this and to save the citizens, whereby the ministry have included that wherever the corporates were spending with respect to the COVID, prevention of this particular COVID, where they are serving to the needy people, they've included that particular spending of amounts as a CSR activity, So whatever the funds that you spend towards the COVID-19 related matters, that will be an eligible amount towards the CSR as per section 135. Clear, everyone? So spending of CSR funds spending of funds for the COVID-19 shall qualify as a CSR amount. Second one, whatever the amount that the donations that you make to the PM Cares Fund, that will also be eligible as a CSR spent amount, CSR activity. Clear? Again, due to this COVID-19, this PM Cares Fund have come up, and lots of corporates have donated some crores of amount for the well-being of India. Clear, everyone? And the last one, amount spent in relation to measures for the benefit of Central Armed Police Forces CAPF and Central Paramilitary Forces CPMF, veterans and their dependents including widows. So for their benefit, whatever the amount that you spend in relation to that benefit, that will qualify as a CSR amount, CSR activity. Clear, everyone? So these are some specific amendments with respect to CSR that is applicable for the December attempt. Apart from these, there are some other amendments that have come in CSR, but to the academical point of view, that will not be applicable for the December attempt, because that was after June 2020 the amendments have come. So that will be applicable for the June 2021. That will be discussed in this separate session. Clear, everyone? So with respect to CSR amendments, these three are the new inclusions which has been made to schedule 7 and which will be applicable for the coming attempt December 2020. Clear? One is with respect to COVID-19 funds, next PM Cares, and CAPF and CPMF is what the new inclusion which is being made to Schedule 7. Clear everyone? So that sums up Companies Act amendments that has come from Jan to June 2020, which is applicable for the December attempt. Clear everyone? So what we have seen, one is with respect to two things with respect to independent directors. One on part of the prosecutions of independent directors and the non-executive directors who are not a promoter or a KMP, where they will not be held liable for that unless you have a strong evidence. Two, inclusion of name in the independent directors data bank to be appointed as an independent director of a company. We have given some time limits over there. By paying a prescribed fee and the examination, passing of examination, that is online self-proficiency test, self-assessment test, a person can be appointed as an independent director of a company. Then you've seen amendment with respect to appointment of a company secretary with respect to a private limited company, where the amounts have been increased. This paid-up capital has been increased from 5 crore to 10 crore, Rule 80A amendment. And Rule 9 has been amended with respect to secretarial audit report, where a new provision has been added up, that is with respect to every company, be it a private or a public company. Earlier we had only listed company and public company, paid up and turnover 50 and 250 crores respectively. But now one more thing has been added up, that is every company, be it a public or a private company, where outstanding loans or borrowings from banks or a public financial institutions is 100 crores or more as per the latest audited balance sheet, then such company shall obtain the secretarial audit report in MR3 from the practicing company secretary and annex that to the board report. Clear? And the last one is about your CSR amendments, that is COVID-19, PM CARES, then CAPF and CPMF. The donations what you make will be eligible towards the CSR activities. Clear everyone? These are the Companies Act amendments. Clear? Can we move ahead? Yes. So now coming to the SEBI LODR regulations. So now regulation 17(1)(b) of LODR regulation. This is dealing with respect to separation of role. Separation of role of chairperson. So if at all you remember, we had discussed this concept in our regular comprehensive batches, where we said that there was a separation of role of a chairperson, where earlier the provision was with respect to April 1, 2020. So with effect from April 1, 2020, there was a separation of role of a chairperson of a listed company, but that has been extended further to 2022, whereby from April 1, 2022, the top 500 listed companies shall comply this particular provision. What is that? The top 500 listed companies, that is listed entities, shall ensure that the chairperson of the board of such listed entity shall be a non-executive director. Shall be a non-executive director. That means the executive director cannot act as a chairperson of the listed company, that is top 500 listed companies. An executive director cannot be appointed as a chairperson. He shall be a non-executive director. And one more thing, and he shall not be related to the managing director or a chief executive officer as per the definition of the term relative defined under the Companies Act. So twofold it is. One, you shall be a non-executive director. Two, you shall not be relating to the managing director and the CEO of the company. Then you can be appointed as a chairperson of the listed company. Sir, you need to check out first of all, you are executive director or non-executive director. If at all executive directors, then ruled out. You cannot act as a chairperson of the listed company, that is top 500 listed companies from 2022 April 1. But if at all you are a non-executive director, then you need to check out whether you are related to the managing director or CEO of the company, of the listed company. If at all you are relating to this managing director or the CEO of the company, then you cannot be appointed as a chairperson. If at all you are not relating to the managing director or a CEO of the company, not related, then you can be appointed as a chairperson of that listed company. Clear everyone? So what it says, with effect from April 1, 2022, the top 500 listed companies, listed entities shall ensure that the chairperson of the board of such listed entities shall be a non-executive director, and he shall not be related to the managing director or a CEO or CEO. So it is or, it is not and, or CEO as per the definition of the term relative under the Companies Act, provided this regulation shall not be applicable to the listed entities which do not have any identifiable promoters as per the shareholding pattern filed with the stock exchanges. So if at all your listed company is not having any identifiable promoters as per the latest shareholding pattern which is being filed with the stock exchanges, then this provision will not be applicable. Clear everyone? This is regulation 17(1)(b). The amendment have come with respect to separation of role. So the amendment here is with respect to, instead of 2020, it has been amended now to 2022. Clear everyone? Then, very important, standard operating procedure for suspension and revocation of trading of specified securities. So very important, in 2020 January, the SEBI have come up with this SOP, standard operating procedure, whereby they have come up with a uniform penalties to the listed companies for whatever the non-compliance that they make with respect to the SEBI regulations. Further, with respect to freezing of demat accounts of the promoters and the promoters group, if at all there was a non-compliance on part of the listed companies, and further suspension of trading of the securities of that listed companies, if at all you are not complying with so and so provisions what has been provided in the annexures, whereby they intend to promote that this listed company shall always try to ensure the compliances, the corporate governance standards on part of the listed companies, because keeping at the interest of stakeholders, where you need to comply with each and every provision, not only the procedural compliances, even the regulatory compliance also be to be complied on part of the listed companies, whereby the hefty penalties have been imposed if there is any non-compliance on part of the company, further extending that to the freezing of demat accounts of the promoters and the promoters group of that listed company as per the recently filed shareholding pattern in the stock exchanges, and also dealing with suspension of trading of that listed companies. So we have got some regulations whereby some non-compliance is there. They have provided 1,000, 5,000, 10,000 per day penalties, whereby they have uniformed all the penalties for the listed companies for certain provisions. Clear everyone? So non-compliance with the certain provisions of SEBI LODR regulations 2015 and the standard operating procedure for suspension and revocation of trading of specified securities. This is what the SEBI has come up, where it says that SEBI has issued a circular specifying the uniform structure, very important, uniform structure for imposing the fines as a first resort. This is a first resort for non-compliance with the certain provisions of the listing regulations. Freezing of entire shareholding of the promoter and the promoter group, and the standard operating procedure for suspension of trading in case the non-compliance is a continuing on or repetitive. The stock exchange shall with having regard to the interest of investors, we said this, interest of investors in the securities market, take action in case of a non-compliance with the listing regulations and follow the standard operating procedure for suspension and revocation of suspension of trading of specified securities. Sir, as a first resort, they're going to impose a penalty and also going to freeze the demat accounts of the promoters and the promoters group of that listed company. And if you still the listed company is making a non-compliance, maybe for a continuous 2 quarters, say for example, if at all they have not complied with respect to appointment of a woman director for continuous 2 quarters, then that qualifies for a suspension of trading, where you'll be categorized as Z category of listed company. So there are certain categories that is being provided. There are certain regulations wherein if at all you don't comply with that particular regulations, then depending upon that particular regulation, your security, penalties may be imposed on you, severe fines will be imposed on you, or there may be a freeze of demat accounts of the promoter or the promoter group of the listed company as per the recently filed shareholding pattern, because in that shareholding pattern you are going to provide who are the promoter and the promoters group. And further, if it is a continuous one or a repetitive in nature, then your securities may be suspended. Your securities may be suspended. Clear, everyone? Henceforth, the stock exchanges shall, having regard to the interest of investors and the securities market, because at the end of the day, you have pooled the amount of public and you are not going in the right direction. There shall be some control where you are put in a right direction, maybe by imposing hefty penalties on you, where you may be complying with certain provisions, where you don't repeat such kind of non-compliances again, and keeping in the interest of securities market, the long survival of the securities market, the SEBI have come up with such operating procedure, where take action in case of a non-compliance with the listing regulations as specified in the Annexure 1, where they are provided in regulations, right? Regulation 7, Regulation 6, Company Secretary, Regulation 6, 17, 8, 19, 20, 24. So likewise, the regulations have been provided where if you don't comply with that particular regulations, then penalty is going to be imposed. That may be ranging from 1,000, 2,000, 5,000, 10,000 likewise per day. So certain penalties may be imposed. That is as far as Annexure 1 is concerned. Annexure 2 is more of a severe in nature. Following the standard operating procedure SOP for suspension and revocation of suspension, it may suspend, where it may give a directions to you to comply with that. If you comply, then they may revoke the suspension. Revocation of suspension of what? Trading of specified securities as specified in Annexure 2 of the SEBI circular number so and so dated January 22, 2020. Stock exchange may deviate from the above if found necessary only after recording the reasons in writing. Clear, everyone? So if at all your offense is a continuous one or a repetitive one, then your shares may be suspended. Clear, everyone? And even the promoters and promoters group share demats may be freezed, wherein you cannot deal in the shares of the companies. Clear, everyone? This is the SOP that has been included in the chapter number 10. Clear, everyone? So two important things, that is Regulation 17 with respect to separation of role of a chairperson, and the another thing that is standard operating procedure. Clear, everyone? This is as far as your SEBI regulations are concerned. Then new topics that has been added up, not new topics actually, again the same amendments with respect to certain codes, certain principles provided by different authorities. Clear? Now first one, new 2020 UK Stewardship Code. Stewardship Code. We have studied this Stewardship Code already in the chapter number 1, if at all you remember, and that has been revised once again, and the new regulations, new principles, not a regulation, new guidelines and the principles have been provided in 2020. They have revised existing guidelines, existing principles, and they have come up with the revised 2020 principles with regard to the stewardship. Clear, everyone? So what it says, stewardship is a responsible allocation, management and oversight of capital to create a long-term value for the clients and the beneficiaries, leading to sustainable benefits for the economy, then to the environment and ultimately to the society. Sir, what is this stewardship? First of all, we have understood this, but what do you mean by this stewardship? So you're managing the assets of different individual, or that and assets may be with respective amounts, or any other assets where you are holding that particular property as a steward for the benefit of so and so person, for the benefit of so and so persons or the individuals. Now in this context, whereby where you are managing the assets of any particular individual, that is asset management companies, asset owners, asset management companies, AMC companies is what we say, asset managers, or any service providers to these particular people, asset managers or asset owners, where you are managing the assets or the properties of different individuals, or you have pooled amount from different individuals, where you are going to manage that particular fund, the pension fund, say for example asset management, where you are going to manage that particular property for the benefit of some other people, in what manner you are going to manage these particular assets. You being a steward, what are the important principles that you have to keep in mind when you are managing these particular assets, is what this UK Stewardship Code talks about, where it says that stewardship is a responsible allocation. You have been put up with certain responsibility for the management of that particular assets, the management of that particular assets, and the oversight of capital, because whatever the amount that you pooled from different individuals, you may end up in investment of some other company. You're going to manage these particular assets, you're going to allocate this particular amount into the equity, so in what manner you are going to view or create a particular value for that particular asset is what depends upon your principles. So oversight of capital to create a long-term value, this is what I was saying, creation of a value, create a long-term value for whom? For your clients and the beneficiaries, for the ultimate beneficiaries, leading to, so it is not only giving any benefits to your stakeholders, to the beneficiaries only. Ultimately, say for example, I've pooled some 500 crores from different individuals and I'm investing in some A company, Now I'm managing in that particular A company, I'm looking after that A company, whether this A company is going within the particular provisions of the law or not, whether this A company is having good corporate governance standards or not. Thereby, it is not only giving benefit to the ultimate beneficiaries, but also to the company, then to the respective society, ultimately to the society, and also to the economy, because the company is going to do good, because there was some constant monitoring on part of your asset managers. Clear, everyone? So it is not only with respect to your beneficiaries, but also to the benefits of the economy, to the environment, and to the society. Why environment have come into picture, sir, here? Sir, corporate governance is not only with respect to the governance of your respective laws. Sir, first of all, what do you mean by a corporate governance? What do you mean by a corporate governance? Though we have discussed in our comprehensive batch, but let us understand again as to what do you mean by a corporate governance. First of all, what do you mean by a governance in a literal meaning? Leave about your provisions of the law, leave about your respective acts, policies and all, whatever it is. First of all, what do you mean by a governance in a literal meaning? In a very layman language, what do you mean by the governance? Simple. Let me take some micro example. Sir, in your family, say for example, your father is saying like this: sir, wherever you go, madam or sir, wherever you go, you have to be at home by 8 o'clock. By 8 o'clock. Or your mother may say that no non-veg on so and so day. You have to prepare like this, or you need to follow this particular schedule, or this is the way we need to behave ourselves. Now what's happening in all these particular cases? Sir, for your respective family, I repeat, for your respective family, there is a particular principle. There are certain particular principles that have been enunciated for your respective family, where your family members shall adhere with that family for that particular principles. I repeat, sir, for your respective family, be a father or mother, whoever it may be, they have promulgated with respect to certain principles which are applicable for your family, and compulsory you have to adhere with that particular principles, so that will give you a benefit. That will give you a benefit. What benefit, sir? Say for example, your sibling is not following but you are following. That itself a very good benefit for you, right? So whatever the general principle that is being drawn in your family, where your family members are compulsory to adhere with that particular principles, that is nothing but a governance for your respective family, because your father or mother have come up with some set of principles, some set of guidelines, some set of policies as to, sir, in my family all the family members shall adhere with this particular systems or the policies. Now your father will not say to the stranger or to the neighbor that, sir, you please follow this. You cannot say to your neighbor that, sir, you have to be home by 8 o'clock. What he'll say, who are you to ask me? Right? So whatever the policy that has been enunciated by your father for your respective family is nothing but a governance for your respective family. Right, everyone? That means there are some systems or policies or procedures that is being set out for that particular organization. Relevant term now, organization, wherein it is expected that the organization and the people of that organization comply with that particular systems or policies or procedures enunciated by such organization. Now coming to the corporate governance now. Sir, governance with respect to your corporate. Sir, with respect to such particular company or a corporate, whatever the systems or policies or procedure has been set out, that has been set out to comply with that particular systems and policies, so as to ensure there is a transparency, so as to ensure that you are protecting the rights of your shareholders and stakeholders. This is nothing but a corporate governance. And not only with respect to your compliance of the law, but also it extends with respect to having a responsibility towards your society and the environment. That is social responsibility. Sir, corporate governance is not only with respect to compliances of the law, compliance of the procedures, compliance of the internal policies. It is further extended to the social responsibility too. Clear, everyone? So that is the reason where it talks about the environment too. Clear, everyone? Then the UK Stewardship Code 2020 is a substantial and ambitious revision to the 2012 edition of the code, which takes effect from 1st January 2020. The code sets high stewardship standards for assets owners. We have said this: assets owners, assets managers, and for the service providers that support them. The code comprises a set of apply and explain principles. Very, very important. Sir, we have understood the concept of comply or explain approach. Also we discussed comply and explain approach. What was that? Sir, you comply a provision, or if you don't comply, you explain me as to why you didn't comply. Say for example, section 135, before the amendment, the recent amendment. Say for example, if you don't comply, that is with respect to spending of that stipulated amount of CSR expenditure, no penalty is going to be levied. You just mention in your board report as to what are the reasons why you didn't spend that stipulated amount of expenditure. So you comply, that means you spend that CSR amount, or You explain me the reasons why you didn't comply. So you comply with that, or if at all you don't comply, then you please explain me as to why you didn't comply with that provision. So you spend that CSR amount, you report that in the CSR annexure. If you don't comply, that means you didn't spend that amount. Then in the board report you mention the reasons as to why you didn't spend that amount. That itself is a compliance. But now there is the different case. You comply with that. If you don't comply, you transfer to the government fund. Or the second one, comply and explain. So you have to comply with that particular provision and also explain me as to how you complied with that provision. I repeat, sir, you comply with that provision. I have complied with the CSR applicability provision, CSR spending of the amount. You explain me how you complied. Sir, I have spent this amount towards so and so, towards with respect to nutrition, towards with respect to prevention, with respect to healthcare, with respect to sanitation. So likewise, I explained as to how I complied with a certain provision. So it may be earlier it was a comply or explain approach, where it has been changed to comply and explain approach. So what it says, you apply that and also explain as to how you complied with that. Or if at all you didn't comply, then you explain me what are the reasons why you didn't comply with that provision. Clear, everyone? So the code comprises a set of apply and explain principles for the asset managers and asset owners, and a separate set with respect to service providers. Clear, everyone? So you have 12 principles with respect to asset owners and the managers, and 6 specific rules again with respect to service providers, which again is a repetitive of the earlier ones. The code does not prescribe a single approach to effective stewardship. Instead, it allows organizations to meet the expectations in a manner that is aligned with their own business model and a strategy. Sir, there is no such thumb rule that says this is a strategy that a company has to comply or adopt to effectuate your stewardship theory or stewardship rules or the duties. So the code doesn't provide you or prescribe you as a single approach or a thumb rule that this is how you're going to effectuate your stewardship rules or duties. Rather, it says that, sir, you please align whatever your objectives are there, business objectives, your goals, you please align with your stewardship theory. You please align these principles to the business objectives. Then that will be in a parallel manner where your economic development will be happening, where you comply with these particular principles. At the same time, your growth will also happen. Clear, everyone? Where the code consists of 12 principles for asset managers and asset owners and 6 principles for the service providers. So the code has specified the following principles for the asset owners and the managers. So what is that? First one, the purpose and governance. So on the basis of purpose and governance, 5 principles have been provided. First one, the signatory's purpose, investment beliefs, strategy and culture enable stewardship that creates a long-term value for clients and beneficiaries, leading to sustainable benefits for the economy, the environment and the society. This is what we have seen here. This one. So what it says, signatories is the one who is going to manage that assets. The owners, asset owners or asset managers who have pooled the amount, who are going to manage the assets of that different individuals, or who are going to invest in some companies, in some investee companies. Sir, I have pooled the amount from different individuals. You being an asset manager, you have been pooled an amount from different individuals. Now I'm talking on part of this signatory. So what it says, what is your purpose? What is your purpose? The investment belief. If at all you are investing these amounts in any investee company, then what is the purpose of that investment? What is the belief that you have in such investee company? And the strategy what you are following for such investment and the cultures that you follow, the investment company follows, the investee company follows, whereby by virtue of that act, by virtue of that investment what you have made in the investee company, where your cultures, your investment decisions, your strategy planning, your purpose will all give a value, a long-term value to the stakeholders, to the beneficiaries, not only to the beneficiaries, also to the economy, also to the society, and also to the environment. Clear everyone? That is first one. Second one, signatories governance, resources and incentives support stewardship. So what it says, sir, within yourself what are the governance that you are following so as to effectuate the stewardship duties? What are the resources and the incentives that you have so that you could effectuate, you can implement the stewardship principles in the investment company and also in the investee company? Then signatories manage conflict of interest to put the best interest of clients and the beneficiaries first. Very important. So say for example, when I pool this amount from the different public and I'm investing in a particular company, and say for example on a future date there comes a transaction between this investment company and that investee company. I repeat, sir, I've pooled different amounts from the public and that amount have been invested in some investee company. Now say for example there's a transaction between me, that is investment company, and the investee company. Then there is a conflict of interest because I've made some investment where that amounts are belonging to certain individuals, where I'm managing that amounts. Now there comes a conflict of interest. Now how you are going to manage that conflict of interest? How you are going to manage that conflict of interest where whatever the activity that you're going to do, that shall be at the best interest and the benefit to the clients and the beneficiaries, ultimate beneficiaries. Clear everyone? Next, signatories identify and respond to the market-wide and systematic risk to promote a well-functioning financial system. Very important. Sir, it is not only about the governance issues, it is also identifying the risk. Identifying the risk. What is the systematic risk? Systematic risk mean beyond your control, uncontrollable risk. Uncontrollable risk. Sir, you cannot control this risk. Say for example COVID-19. Obviously it is beyond your control. Where all these institutional investors, your asset management companies, if at all, not exactly the COVID-19, but whatever the case it may be, we cannot, of course, we cannot, identify that, sir, COVID-19 is going to come. Of course, we cannot, but depending upon the market scenarios, you may identify a risk. You may identify a risk. And what are the policies that the investment companies are having, the asset management companies are having? What are the mechanisms that you are having so as to identify the risk, so that you can identify the risk, whereby of course you may not eliminate the risk, rather you may try to minimize the impact of risk in your investing company such that you provide a greater benefit to your clients and the beneficiaries. So it is not about risk elimination, which may not be possible in the business scenario. Rather, it is more about a risk minimization. Risk minimization, minimizing the impact of that potential risk that may have on your organization. Clear everyone? So whenever we take the concept of risk management, it is not about risk elimination. It is rather identifying and minimizing the impact of risk, which is what the risk management is concerned about. So you being this investment companies, what are the mechanisms that you are having within yourself so as to identify the risk, potential risk, which are beyond your control, and what are the mechanisms that you are having as to how you're going to respond to that particular risk. Now say for example, now current scenario. So the scenario when you take the about January or December 2019 and to the December 2020, the scenarios have been changed. There are potential risks with respect to the continuity of the business, some sort of business. Now how you are responding to that particular risk, what are the mechanisms that you are having, is what matters there. And the last one, signatories shall review their policies, assure their process, and assess the effectiveness of activities. Sir, once you have a policy of your stewardship, doesn't mean that that will survive the purpose for the long term, because depending upon the changing scenarios, you need to review your policies and make changes accordingly so that you could provide a benefit to your beneficiaries. Clear, everyone? So review your policies and assess from time to time on a periodical intervals, such that wherever the changes required with respect to your policies or the mechanisms, you could do so. Clear, everyone? That is with respect to purpose and governance. Next, with respect to investment approach. Now, sir, you pool the amounts. Now you intend to invest in some companies, in some investee companies. Now whenever you are investing, what are the investment approach, what shall be the approach and part of the investment company, is what principle 6, 7 and 8 talks about. So what it says, signatories shall take into account the client and beneficiary needs and communicate the activities and outcomes of their stewardship and investment to them. So sir, in which companies you are making such investment, in which companies you are making such investment, and what is the requirement of your beneficiary, what is the need of your beneficiary, you need to create a framework for these two. So depending upon your requirement and the needs of your beneficiaries, some may require a long-term value, some may require a short-term approach. So depending upon the requirement of your clients and the beneficiaries, your approach shall be different, whereby your portfolio may be different, where the activities what you have considered, the outcome of that particular investment shall be disclosed to your respective clients and beneficiaries. Next one, signatories systematically integrate a stewardship and the investment, including the material, environmental, social and governance issues and climate change, to fulfill their responsibilities. Sir, it is not only with respect to finance oriented investment, it is not only with respect to return oriented investment. Why? Sir, corporate governance is not only dealing with respect to your EPS only. It is not only talks about your profit motive organizations. It's not only driven with respect to your market, with respect to your profit. Rather, it is much more beyond that. Rather, it is not talking about any monetary terms here. It is more about compliance of the law. It is more about your environmental. It's more about your sustainable development. It's more about social responsibility. So it is not with respect to the how much profit that you are making. Rather, whenever you are making any investment in the investee companies, what are the factors that you are considering apart from your finance activity, the finance regulations of these particular companies, about the history of the EPS or the profit that is being made by the company. Apart from these, what are the governance levels of the company, what are the compliance levels of the company, what is the history of the non-compliance of the companies, what are the history of penalties of the companies, existing penalties, existing prosecutions over the company, whether they are making any efforts towards the social development, sustainable development, apart from the economical development. So all these issues are to be considered, all these issues are to be checked out before you make an investment in the investee companies. So it is not only about your profit motive, rather you need to check out your social and economical guidelines, environmental guidelines, then you take a decision. Clear, everyone? So that is what we say, ESG guidelines, right? Environmental, social and governance. Then the last principle with respect to investment approach, that monitor, the signatories shall monitor and hold to account the managers or the service providers. So when you are making any investment in these investee companies, you always monitor that investee companies, and you please integrate with that companies, engage with that companies, and constant monitoring shall be there on part of these investee companies. Then Next head with respect to your engagement. So with respect to engagement, you have three principles, 9, 10 and 11. That is more about engagement and the participation, active participation. Stakeholder participation is what we say. So active participation of these asset managers with this investee companies. So what it says, signatories engage with the issuers, that is investee companies, to maintain or enhance the value of the assets, and wherever necessary participate in the collaborative engagement to influence the issuers. Sir, not only you, with other asset managers, you make a collaborative agreement, you combine yourself as a single force and go with respect to a particular issuer for such that it could be a benefit to your beneficiaries. And principle 11, signatories wherever necessary escalate. What do you mean by escalate? To increase, to gear up, to increase the stewardship activities to influence the issuers, So whatever the factors that you are considering there, whatever the mean it may be, as far as it is relating to your stewardship activity with the intention of getting a benefit to your stakeholders, that could be a good one. Clear, everyone? Then the last one, exercising the rights and responsibilities. So obviously, whenever you are making such investment, where you're having a major role to play, because you're going to end up making investment of some crores of amount. Say for example, an individual may invest, say for example, a 10 lakh or 1 lakh, but these institutional investors or these asset managers may end up investing 500,000 crores. So you're having a value over in that particular company. So you have to raise up your voice whenever this company is going beyond a particular law, or wherever you think that this could be done in a better manner, then you exercise your rights and responsibilities. So signatories actively exercise their rights and responsibilities. Clear, everyone? So these are the 12 principles that has been provided with respect to the asset managers and the asset owners, and some separate set of principles has been provided with respect to service providers, and again these principles remain same as what we have seen till now. So we'll just have a look what it says. The same thing, purpose, strategy and culture enable them to promote effective stewardship, and this is what we have seen here: purpose, investment, belief and culture. Then signatories governance, workforce, resources and incentives enable them to promote effective stewardship. Again, this is the same point what we've seen. Then identifying and managing the conflict of interest, the same concept once again, because see, this is with respect to specifically on part of service providers, and the earlier one, that is with respect to your asset managers and the asset owners. Signatories identify and respond to the market-wide and systematic risk. Systematic risk means it is systematic, it is not systemic. Systematic risk, that is uncontrollable risk, to promote a well-functioning financial system. Even here you have to make this systematic risk, that is. Then signatories support clients' interrogation of stewardship and investment, taking into account material, environmental, social and governance issues, ESG guidelines is what we have seen, and communicating what activities they have undertaken. This one, principle 7. And the last one, review their policies and assure their processes. Clear, everyone? So this is the at the global level UK stewardship, whereby the UK stewardship codes have been revised with the existing of 2012 edition. Their revision has been made 2020 Jan 1. Clear, everyone? An expected question for the December attempt. Clear, everyone? So can we move ahead? The last topic, that is the stewardship code for insurers in India. So at the global level it is being amended. So ultimately, obviously this will be amended in the Indian perspective too. So 7th February 2020, where the Regulatory Authority of Insurance, that is IRDA, has revised the existing guidelines, the stewardship code for the insurers, which was originally been implemented in 2017, or applicable from 2017-18 financial year. So after almost 3 years, or 3 financial years, in February 2020, they have revised the existing guidelines, existing principles for the institutional and the insurance companies. Clear, everyone? So what is this? The insurance companies, whereby where you pay certain premiums to these insurance companies, where you take the life insurance or the general insurance, whatever the premiums that is being collected by these insurance companies, obviously they're going to make some investment in some other investee companies, otherwise how they're going to pay you the amounts? So obviously they're going to make investments. Now whenever you are making such investments, tell me whose amount is this? So about the public amount. So again the stewardship role comes into picture, because you are holding a property of someone else. So whenever you are holding such amounts of some other people, in what manner you are going to hold this as a steward is what the principles what we are going to study now. Clear? So IRDAI decided to review the existing guidelines, that is 2017 guidelines on stewardship code based on the experience in the implementation compliance by the insurers and the recent developments in this regard. Accordingly, a revised guidance on stewardship code has been prepared and placed herewith as a revised guidelines on a stewardship code for insurers in India. All the insurers need to review and update their existing stewardship policy based on the revised guidelines on stewardship code for insurers in India within 3 months from the date of issue of the same, and updated stewardship policy need to be approved by the board of directors. Sir, on 7th February 2020 it is been released, so within 3 months you need to update your stewardship policy, and that policy has to be approved by your board of directors, and also you shall make up disclosures, and wherever you have a website you host that your stewardship policy. So what it says, the updated policy shall be disclosed on the website within 30 days with the approval of the board alongside the public disclosures. Clear, everyone? So within 3 months of the release of these particular guidelines, you need to amend your existing stewardship policies and update with regard to the new additions, and also you need to host that. First of all, you update your stewardship policy in accordance with the newly released one and get it approved by your board of directors. Then that has to be hosted on the website of the insurance companies. Clear, everyone? Then any subsequent change or modification to the stewardship policy should be specifically disclosed at the time of updating the policy document on the website. So what are the principles and the guidelines? First one, insurers should formulate a policy on the discharge of their stewardship responsibilities and publicly disclose it. So the same principles again, some modifications have been provided including the guidance part. So what it says, sir, you being in insurance companies where you are going to invest in some investee companies, you shall have a clear policy as to how you are going to engage and implement your stewardship role and responsibility, implement your stewardship duties. You shall have a clear-cut policy, and you please publicize that. So what it says, insurers should have a policy, formulate a policy on discharge of their stewardship responsibilities and publicly disclose that. So what it says, stewardship activities includes monitoring and engaging with the companies on matters such as strategy, performance, risk, capital structure, and the corporate governance, including the culture and the remuneration. So, sir, wherever the investee companies in which you are making some investment, where you are going to engage with that investee company with respect to the risk factors of the company, the strategy of that investee company, the culture of that respective company, the decision making and the strategy making of that investee company. So all these particular things you're going to engage with that investee company, whereby you're going to discharge your stewardship responsibilities. The policy should clearly define the stewardship responsibilities as identified by the insurer and how it intends to fulfill the same to enhance the wealth of its clients. Sir, whatever you identified as your responsibilities, you need to include in your policy. At the same time, how it will generate or how it will increase the wealth of your client, you need to mention in your policy. The policy should also disclose how the insurer applies the stewardship with the aim of enhancing and protecting the value for the ultimate beneficiary or the client. Sir, you please provide in your policy as to what are the different mechanisms or the policies that insurance companies will be taken into consideration for creation of value of your beneficiaries by exercising the stewardship code. I repeat, sir, you being an insurer here, what are the different mechanisms that you are going to comply or implement with relation to the discharge of your stewardship role, so that will give a benefit to your respective beneficiary, ultimate beneficiary. Insurers should have a clear policy on how they manage the conflict of interest in fulfilling their stewardship responsibilities and publicly disclose it. Sir, what was the first one? First one, you shall have a policy. You shall have a policy and you publicly disclose it. Second one, you shall have a policy with respect to what? With respect to conflict of interest. Conflict of interest. So what it says, the insurer should put in place, maintain and publicly disclose a policy for identifying and managing the conflict of interest with the aim of taking all the reasonable steps to put the interest of their client or a beneficiary first. The policy should identify the scenarios of likely conflict of interest as envisaged by the board of directors. I should also address how matters are handled when the interests of the clients or beneficiaries diverge from each other. So I've discussed this in the earlier code too, UK Stewardship Code. So whenever there is a conflict of interest, how you being an insurance company, institutional investors or asset managers or asset owners in the earlier case, how you are going to manage that conflict of interest such that your clients or your ultimate beneficiaries are not at loss, and wherever you are going to manage this conflict of interest, that shall be at the best interest of your beneficiaries, where beneficiaries shall be put first, then to you. Clear, everyone? Then third one, insurers should monitor their investee company. Obviously, very important one. Sir, once you made an investment in that investee company, obviously you need to monitor that investee company, unless you are not going to give any benefit to your beneficiaries. So what is the third one? Monitor the investee company. So what it says, insurers should have a mechanisms or policies for the regular monitoring of the investee companies in respect of what? The performance, the leadership effectiveness, the succession planning, the corporate governance, reporting and other parameters they consider important. Sir, for each and every company there are different parameters. So we cannot say that, sir, these are the parameters for all the companies, for all the portfolios that you have. No, I cannot say that. Say for example, simply if I have 50 lakh rupees with me and if I want to make investment in the securities market, now if I look into the information technology company, the parameters what I look into will be different. The food business and the hotel business, the parameters what I look into is different. Yes or no? Because information technology, the parameters what you look into maybe with respect to a long-term approach, where everything may be into electronic form. Food business maybe as of now it may be low due to COVID. So likewise, depending upon the market scenario and the facts and circumstances as on that particular date, the parameters what you may look into, the factors what you may look into for your investment will be different. So depending upon your investee companies, what are the different parameters that you are looking into, what are the different mechanisms that you are having, such that you are monitoring your investee company. Clear, everyone? Then insurers may or may not wish to have more participation through nominations on the board for active involvement with the investee companies. An insurer who may be willing to have nominations on the board of an investee company should indicate in its stewardship statement the willingness to do so and the mechanisms by which this could be done. A nomination on the board of the investee company by the insurance companies. Yes, you may provide such clause in your policy. How you are going to implement that? How you are going to nominate a director on the board of that investee company such that your interest of your beneficiaries may be hold good, may be secured, may be protected. So in what manner? What is your strategy? What is your policy with respect to appointing a nominee on the board of directors of the investee company? You please disclose that in your policy. Clear, everyone? Then fourth one, you shall have a clear policy on intervention in their investee companies. Intervention in the investee companies. That means your engagement, active participation in the investee company. Sir, first of all, here what you said, it's only about your monitoring the investee company, controlling the investee company. Here it is participating in the investee company. How? Insurers should set out the circumstances in which they will actively intervene and regularly assess the outcomes of doing so. Sir, how you are going to actively participate in that company? By attending the meetings, or by nominating a director, or by making a performance evaluation on periodical intervals, or based on the financials part, based on the non-financials part, based on the leadership qualities, based on the succession planning, or what are your parameters, what are your circumstances whereby you're going to engage yourself with that investee company, irrespective of the amount of investment what you made. Very important. Irrespective of the amount what you have made investment in that investee company. That is what it says. In addition, a low volume of investment is not a reason for not intervening. Sir, irrespective of your investment amount, it's not about the equity investment here. It's not about the amount of investment what you made. It is about the intervention what you are making, so that could be a benefit not only to your not only to your beneficiaries, but to the stakeholders at a large, and at the end to the economical development and the societal changes. Clear, everyone? So it is not about the amount of investment what you made, rather how you are participating yourself so that could reap a benefit to the ultimate stakeholders and the ultimate beneficiaries. Clear, everyone? Instances where when insurers may want to intervene include but not limited to. So this is a specific one. So these may not be a perfect one. Depending upon the investee companies, that may change. So do not limit your interventions only to these factors. So what are those? About the company's strategies, the performance, the governance, the remunerations, approach to the risk, including those that may arise from the social or environmental matters. These are some factors where you need to consider. Clear? Then, insurers should have a clear policy for collaboration with other institutional investors where required to preserve the interest of policy holders, ultimate investors, which should be disclosed. So the fourth one we have discussed that. What is that? Intervention. Intervention in investee companies. Next one is collaborations of whom the insurance companies. So what it says, you shall have a clear policy. So for issues that require a larger engagement with the investee company, insurers may choose to act collectively with the other institutional investors in order to safeguard the interest of their investors. For such situations, the insurers should have a policy to guide their actions and extent of engagement. Sometimes unity may be giving a benefit, more benefits to your ultimate beneficiaries. Then you create an engagement with some other institutional investors of the insurance companies where you're going to act collectively in that investee company where your voice may be increased. Clear, everyone? So if such is the case, then what is your policy in engaging with that or in collaborating with that another institutional investors. So you have a policy for that too. Clear? See, if at all you observe all these things dealing with respect to policies only. So you have a policy. In that policy you mention as to how you are going to monitor, how you are going to intervene in these investing companies, how you are going to manage the conflict of interest, how you are going to collaborate with other institutional investors is what it talks about. Then insurers should have a clear policy on voting and disclosure of voting activity. So it talks about the voting part. See, why voting is required. Sir, say for example, you have invested some amount in a company, in a Reliance company. So say for example, I have invested in a Reliance company. I am residing in Hyderabad. Now, say for example, I am holding one share, only one share for example. And there is an extraordinary general meeting tomorrow for whatever the purpose it may be. And I have received a notice as I being a member. Now to vote that particular share, to vote that particular vote, it is the right to vote on part of me. I want to go to the respective place, say for example Bombay, to exercise my vote with respect to one share. Practically is it happening? No. Thereby what has come? E-voting procedure have come. Still e-voting process, yes, it is giving some benefits, but not to the extent. All shareholders may or may not participate in that voting. But when you talk about these institutional investors, these insurance companies where they have invested a huge amount of investment in that companies, in that investee companies, where you are representing so many people, where you are managing the amounts of different individuals, where it is expected from you to vote, to exercise your voting rights in such investee company, and whereby so simply you say you please go and vote, insurance companies may not come up, and whereby by these particular codes, so by these principles, IRDA mandated with certain slab rates have provided certain amounts of asset under management depending upon the assets under management and the amount of investment what you have made. They are mandated with respect to voting. We'll discuss that. So what it says, insurers should not just blindly support the board of directors of the board of the investee company, but instead take their own voting decisions to promote the overall growth of the investee companies and in turn enhance the value of their investors. So simply, if at all you are holding any shares and you get the ballot paper, simply I assent, and you give the assent for all the resolutions within no matter of time. But you being a shareholder, see, I'm not talking about the institutional investor now, as a shareholder, have your own decision making for whatever the item of business that is being provided there. Do not think that is it benefit for the company or not. Do not think whether it is benefit only for the board of directors or the respective individual. Think whether it is benefit for the company. Think whether it is benefit to the shareholders, whether it is creating a value to the company, whether it is giving any addition to the environmental or social development. So all these factors need to be considered. Then give your vote, be it assent or a dissent. Clear, everyone? So insurers should not just blindly support the board, rather take their own decision making to promote the overall growth of the investee companies, whereby it enhances the value of their investors. The voting policy should be publicly disclosed. The voting decision taken in respect of the investee companies should also be disclosed publicly along with the rationale for such decision. Then insurers should disclose the use made, if any, of the proxy voting or the other advisory services. So if at all you have taken any services from the advisory people, advisory services you have taken, then you publicly disclose that. They should describe the scope of such services, that is advisory services, identify the providers and disclose the extent to which they follow, rely upon or use the recommendations made by such services. See, we have these advisory services firms whereby they read these investee companies, they make a study of these investee companies, they make a study of progress of these investee companies and provide as to whether you can continue your investment in this investee company or not, with respect to your agenda items, that is with respect to voting items, they provide an advice whether you could go against it or you could go assent of that particular resolution. So they provide the advisory services. So if at all you are availing such advisory services, then you publicly disclose that. Then insurers should mandatorily, very important provision, undertake active participation and also voting on resolutions or proposals of the investee companies under the following circumstances. Size of the AUM. AUM means assets under management. Assets under management of the insurer in crores. And read the lines here. Compulsory voting required. Compulsory voting required when if the insurer's holding of the paid up capital of the investee company is 3% and above and 5% and above. Listen here. We're talking about the insurer's holding in the investee company. So depending upon the holding of that insurers in that investee company in relation to its assets under management value, it is providing the mandatory voting. So what it says, sir, if at all your insurer's AUM value is up to 2,50,000 crores, then and if your stake is 3% and above in that investee company, then mandatorily you shall vote. Mandatorily you shall vote. If at all your AUM value is more than 2,50,000 crores, above 2,50,000 crores, and your investment is 5% and above, then mandatory voting is required. Not understood. What it says, see, there is an insurance company. Right? There is an insurance company where AUM value is up to 2,50,000 crores or above 2,50,000 crores. This is one criteria. This is with respect to AUM criteria. The other criteria is with respect to your holding of the paid up capital of the investee company. So what it says, sir, if at all your AUM value is up to 2,50,000 crores and if at all your investment is exceeding 3% of paid up capital of investee company, I repeat, if at all you being an insurance company where your AUM value is up to 2.5 lakh crore and you are holding more than or equal to 3% of paid up capital of the investee company, that means in the shareholders list of the investee company you are a shareholder holding more than 3%, then compulsory you need to vote. That means what is the contrary to that? Sir, your AUM value is up to 2.5 lakh crore, but you're not holding 3%. Say for example, you're holding 2.5%. Then it is not mandatory. So two things. Sir, your AUM value is up to 2.5 lakh crore and you're holding more than 3%, 3 or more than 3% of the paid capital of the investee company, then mandatorily you need to exercise your voting rights. Same way, sir, your AUM value is about 2.5 lakh crore and the checklist is with respect to 5%. If at all you're holding more than 5%, and above of the paid up capital of the investee company, then compulsory you need to exercise your voting rights. Otherwise, not. Clear, everyone? So two things you need to check out, my dear friends here. One is about your AUM value, that is up to 2.5 lakh crore. Then check out whether you're holding more than 3%, 3 or more than 3% or less than 3%. If at all you are holding less than 3%, it is not mandatory to vote. But if at all you are holding 3% or more than 3%, compulsory these institutional investors or the insurers shall vote. Same way, if your AUM value is about 2.5 crore, then you need to check out your investment value, the percentage, that is 5% and above or less than 5%. If it is less than 5%, it is not mandatory. If it is more than or equal to 5%, then you need to mandatory register that. Clear, everyone? And the last one, insurers should report periodically on their stewardship activity. Periodical reporting. So where are we? This one, yes. Sixth one is with respect to voting, and the last one, that is reporting. So what it says, in addition to the regular fulfillment of the stewardship activities, institutional investors should also provide a periodical report to whom? Obviously to the ultimate beneficiaries, as to how they have discharged their responsibilities in a format which is easy to understand. However, it may be clarified that the compliance with the aforesaid principle does not constitute as an invitation to manage the affairs of the company or preclude a decision to sell a holding when this is considered in the best interest of the clients or beneficiaries. Very, very important. Sir, please understand what he is talking about. It is clarified that compliance with the aforesaid principle does not constitute an invitation to what? Invitation to manage the affairs of the company. So the principles is been provided to the insurance companies or the institutional investors to actively participate in the investee companies for the benefit of the beneficiaries, but not with respect to controlling that investee companies. The target of these principles is not to control or manage the affairs of the investee companies or preclude a decision to sell a holding when this is considered in the best interest of the clients. So you don't have any right to sell off the undertaking of investee company. Clear, everyone? So what is the intention of these principles? Sir, you being a steward where you are holding an amount of different individuals or public, in what manner you are going to manage these funds at the best interest of your ultimate beneficiaries is what the target of this particular stewardship rules or principles. Clear, everyone? But not with respect to managing the affairs of the investee companies. Clear? So this is the stewardship principles with respect to insurers in India. Clear, everyone? And these are the amendments that are applicable for the December 2020 attempt as far as GMRCE concerned. Clear, everyone? Any doubts? Any doubts? Sir, with respect to the examination point of view, the focus shall be much upon the part 2, part 3, part 1 and part 4 as already discussed in the classes, in the comprehensive batches what we had. Clear, everyone? So part 2, part 3, only of 3 chapters that you have, but it's almost 40 mark. So at least you need to get 30 plus. Then surely you are able to get that 60 plus in this particular subject. Clear, everyone? So these are the amendments which has come up, which are applicable for the December attempt. Clear, everyone? So if at all you have any doubts, you can call to these particular numbers, or you can visit the website for the books or the classes, whatever the case may be. Clear? Or you can also have a mail ID over there in the website too, or even the description to the link. You'll be having that mail ID too. So you can call me, you can text me, and please do clear your respective doubts. Clear, everyone? So all the very best for your examination. Please complete all these amendments too. You can get this PDF copy. I've just condensed a matter here. Just give a call, you can get this part. No issues with that. Clear, everyone? All the very best for your examination. Please take care. Bye-bye.